TCC Judgment 113 Champagne 1, 2024. Case on the extended confiscation of criminal proceeds in narcotic cases. Head notes: Article 19, Paragraph 3 of the Narcotics Hazards Prevention Act, hereinafter the Provision 1 and the NHPA, and Article 2, Paragraph 2 of the Criminal Code, hereinafter Provision 2, are constitutional. The extended confiscation scheme under Provision 1 is a non-conviction-based measure that is non-penal in its nature. Provision 1 does not concern the principle of non penal sine lege, the principle of non penal sine culpa, and the presumption of innocence. The term other illegal acts in Provision 1 can be deduced as criminal activities. The provision meets the requirement of the principle of clarity of law, the principle of clarity and the precision of legal provisions. Provision 1 conforms with the constitutional right to a fair trial and the right to institute legal proceedings. In terms of the standard of proof, for ordering extended confiscation, the court must consider all evidence and balance the probability that if there was a high possibility that the asset in question were unlawfully obtained. Defendants must have the opportunity to argue and defend themselves. Provision 2, which in practice allows extended confiscation to apply to narcotic cases committed before the implementation of Provision 1, is a law with force retroactive effect, thus not violating the principle of lex retro non-agit, principle of non-retroactivity, and the legitimate expectations. Background note: in 2020, Taiwan adopted the extended confiscation scheme in the amendment of Provision 1 to prevent drug-related crimes. The provision allows the confiscation of illegal gains to be extended to those obtained from unlawful activities other than those drug crimes for which the accused is convicted. Furthermore, Provision 2 stipulated that the confiscation of proceeds shall apply the law enforced at the time of judgment. Provisions 1 and 2 combined made it possible in practice for courts to order extended confiscation in narcotic cases before 2020. The petitioner of this case, Yi Hui-chi, was seized with her spouse with manufacturing Category 2 narcotics in 2019. During the investigation, the police also seized the NTD 97,093,700 in cash. The court of the first instance found the petitioner guilty and ruled that 92,870,000 were illegal profits obtained from other illegal activities. The court ordered the amount to be confiscated under Provisions 1 and 2. This decision was upheld by the appellate court and was final after the appeal was dismissed by the Supreme Court. The petitioner lodged a constitutional complaint against the Provisions 1 and 2, arguing that the Provision 1 is penal but was unclear in wording. Provision 1 lowers the standard of proof for the prosecutor to secure a court-ordered confiscation, and that applying Provision 2 with Provision 1 will result in retroactive application of Provision 1, which violates the principle of lex retro non-agit. Judgment 113 Champagne 1, 2024 was announced on January 26, 2024. Justice Xinlian Jian wrote this judgment. 2 concurring opinions and 3 dissenting opinions were filed. Summary of the judgment. Holding: Provision 1 as amended January 15, 2020 and implemented July 15, 2020 stipulated that when offense as stipulated in Article 4 to 9, 12 to 13, 14, paragraphs 1 and 2 are committed, and when there are sufficient facts supporting that the property or property interest other than those described in the preceding 2 paragraphs possessed by the offender were obtained from other illegal acts, such property or property interest shall be confiscated. Provision 1 does not concern the principle of non penal sine lege, the principle of non penal sine culpa, and the presumption of innocence. The term other illegal acts shall be construed as conduct of criminal nature. The prosecution shall bear the burden of proof to provide sufficient facts supporting that the property or property interest possessed by the offender were obtained from criminal conduct other than the one for which the offender has been convicted. Such proof shall be sufficient if the court, after comprehensive review of the evidence and balancing the probabilities, is satisfied that there is a high possibility that the property or property interest hereinafter together as assets were yielded from other illegal acts. However, the court shall not determine as such simply because the defendant could not clarify the legal sources of his or her assets. The defendant's right to present an argument and a motion for evidence examination shall be fully protected during trial, which could further protect the defendant's right to a fair trial. In this respect, Provision 1 does not violate the principle of clarity of law, the constitutional principle of proportionality, and the constitutional principle of a right to a fair trial. Provision 1 also conform with the protection of the right to property and the right to institute legal proceedings under Article 15 and 16 of the Constitution. 2. Provision 2, as amended December 30, 2015, and implemented July 1st, 2016, stipulated that confiscation of proceeds shall apply the law enforced at the time of judgment. The part of Provision 2 involving Provision 1 does not concern the principle of non penal sine, and does conform with the principle of lex retro non agit and the principle of legitimate expectations. 3. The petitioner's complaint shall be dismissed.